Welcome everyone to this final lesson for our Master 1 Business Law course. I'm thrilled to have you all here as we wrap up our journey together in exploring the English language, particularly in the context of addressing the abuse of company funds and the misuse of voting rights. Throughout this course, we have delved into critical concepts that are essential for your future careers in law and business. I encourage you to engage actively in this session as your insights and questions are valuable. Let's make this last lesson a memorable one. Thank you for your dedication and hard work. Let's get started. For the table of contents, we have the introduction to legal framework, introduction to criminal liability of managers, abuse of company funds, key elements of the crime, divergent doctrinal views on company interests, introduction to abuse of authority or voting rights, abuse of authority, legal and procedural aspects, fault in management, positive and negative faults, piercing the corporate veil, addressing misuse of limited liability, judicial evolution of managerial fault. Also, we have the conclusion and key takeaways. Introduction to legal framework on abuse of company funds and authority. Abuse of company funds or reputation. Company board members are held criminally liable for offenses committed in the course of managing and administrating company assets. This liability is outlined in Article 811, paragraph 3 of the Commercial Code, which states the chairman of joint stock company, as well as its administrators or general managers who intentionally use the company's funds or reputation for purposes they know to be contrary to its interest, for personal benefit, or to favor another company or institution in which they have direct or indirect interests. It is important to note that although this crime may be committed by an individual, manager, or even the entire administrative body, it cannot be attributed to the company itself, as it is a moral person. The judiciary has not clearly distinguished this offense from breach of trust, often treating them similarly due to the overlapping elements and the lack of detailed regulation in the Commercial Code. The objectives are understanding the abuse, the elements of the crime. For the crime of abuse of company funds or reputation to be established, the following elements must be presented. Firstly, use of company funds or reputation. The legislator has given a very broad scope to the concept of abuse, company funds or reputation, encompassing not only criminal acts but also the subject matter of those acts, with the aim of providing real protection to the company and its interests. Indeed, the term used includes all legal transactions, whether aimed at disposal or mere management, such as lease, advance payments, or gratuitous use commoditum, as well as physical action taken by managers in the course of their duties. This element distinguishes the crime of abuse of company funds or reputation from breach of the trust, which requires misappropriation or embezzlement resulting in the removal of assets from the victim's estate. In contrast, the former crime exists even if the assets remain within the company assets. However, the term has inherent limits. The Commercial Code punishes only the act of using funds. Therefore, non-use or abstention from use falls outside the scope of punishments. These passive behaviors remain unpunished, even if their consequences harm the company's interests. So, a manager commits the crime if he allocates company property for purposes conflicting with its interests, use company liquidity to pay fees for legal proceedings targeting him personally, waives a patent while continuing to receive payment related to the invention, despite the company having funded all research and development costs. Finally, the crime is complete when the company's reputation is abused. Company reputation refers to its ability to borrow money, for example, its financial standing in dealing with third parties based on its capital, business success, and guarantees offered to the creditors. Example, signing promissory notes in the company's name to secure personal debts, guaranteeing a loan for a private residence under the corporate entity. The crime is considered committed even if the manager is financially solvent, making the guarantee merely formal, provided the act endangers the company's patrimony. For the second element, abuse use of company funds or reputation, punishment is imposed only if the use of company funds or reputation constitutes abuse. This occurs when the use serves personal purposes or interests conflicting with the company's interests. The use contrary to the company interests. Managers are not mere agents of shareholders entrusted solely with managing invested capital. They are organs of the legal person responsible for managing the company as a whole. Thus, the validity of their actions is assessed based on whether they serve the company's overall interests. Acts constitute abuse if they deviate from this purpose. The subjective element or bad faith intent, the law requires that the misuse be done in a bad faith and that the manager knowingly uses the funds or reputation for purposes contrary to the company's interests. For the divergent doctrinal views on the definition of company interest, there is a disagreement among scholars regarding the definition of company interest, a key element in establishing this crime. Shareholder interest theory. Some scholars link the company's interest to the interests of investors, shareholders, or shareholders who contributed to its capital, while prevalent in Anglo-Saxon jurisdictions under the theory of corporate governance. This view is rejected by Algerian Commercial Code, which explicitly states that the shareholder approval does not erase criminal liability. Commercial Code, Article 715 bis 25, paragraph 2. The majority interest theory. Others associate company interest with the majority shareholders' interest. However, this approach is also problematic. Dominant view or economic project interest. The prevailing modern doctrine supported increasingly by court and legislation, links the company interest to the economic project of or enterprise itself. This is seen as a common interest around which various particular interests revolve. For example, bribery to obtain contracts may be justified if it benefits the economic project and generates profit. However, if it leads to failure, it constitutes abuse of company funds. بالنسبة للمصطلحات باللغة العربية لدينا التعسف في استعمال أموال الشركة، المقابل لها abuse of company funds. التعسف في استعمال سمعة الشركة abuse of company reputation. خيانة الأمانة breach of trust or embezzlement. الركن المادي للجريمة material element. الركن المعنوي للجريمة moral element. مصلحة الشركة company interest. كذلك مجلس الإدارة board of directors. المسير administrator or manager. الشخص المعنوي legal person. For the criminal liability of managers in case of criminal offenses, in addition to the crimes stipulated in the Penal Code, the Commercial Code has also criminalized certain actions committed by company administrators. Examples include distribution of profits contrary to legal provisions of the company's bylaws, abuse of company funds, abuse of authority or voting rights. However, since the criminal liability that may be borne by commercial managers arises from numerous wrongful acts, too many to cover comprehensively, in this study we will focus on a specific category of criminal acts performed by these individuals within the framework of exercising their powers, whether related to management or directorial functions. Therefore, we shall address firstly abuse of company funds or reputation in the first subsection, and secondly abuse of authority or voting rights. We must distinguish here between two types of rules that address the issue of penalties: substantive rules and procedural rules. Substantive rules. These rules determine who is held liable for committing the offense and specify the penalties imposed on the perpetrator مرتكب الجريمة. Firstly, persons identified in Article 811, paragraph 3. Since criminal punishment is personal, it applies only to the board member who committed the act. It does not extend to other members unless they participated in committing the offense. Furthermore, the company itself as a legal person is not subject to criminal liability, as criminal law does not punish moral persons. Firstly, the principal offender. The legislator has correctly intervened by specifying that the principal offender is in the offense of abuse of company funds or reputation is the manager or someone acting in his stead, that is, a legal or de facto manager. As for the legal manager, Article 811 refers to him as the chairman of a joint stock company, meaning the chairman of the board of directors and the general manager or administrator of the company. This also includes any permanent representative of the legal person who is a member of the board of directors. Therefore, he bears the same civil and criminal responsibilities as if he were managing the company in his own name, without prejudice to the joint liability of the legal person he represents. Commercial Code, Article 612, Paragraph 2. It is clear from an interpretation of Article 811, Paragraph 3, that the legislator specifically referred only to managers of traditional joint stock companies and did not explicitly mention administrators in companies governed by a board of directors or supervisory board. Does this rule apply equally to them? In other words, are they criminally liable for abuse of company funds or reputation, as is the case with older forms of companies? In practice, there is difficulty in applying this provision, and the judge must consider two approaches. Either interpret the text strictly and literally, in which case the provisions on abuse of company funds or reputation would not apply to members of the board of directors or supervisory board, given the clarity of the legal text. No expensive interpretation of the penal provision should be made in accordance with the principle stated in Article 1 of the Penal Code. There shall be no crime, penalty, or security measures except by law, or adopt a board interpretation of Article 811 to include members of the board of directors who commit such offences. Despite the silence of the law, it is unreasonable to exempt those administrators who have wronged the company and its creditors. Therefore, we must lean toward an expansive interpretation of Article 811 to include members of the board of directors in order to close this legislative gap. While this raises questions regarding the basis of liability, it remains necessary. What is striking is that the legislature granted the supervisory board the same powers as those assigned to the board of directors. Thus, it may be reasonable to extend the application of the aforementioned article to members of the supervisory board. However, the legislature's silence on this matter should not persist indefinitely, and corrective action is needed to avoid recurring legal ambiguities. As for the second category, the de facto manager, there is no doubt about his criminal liability for the offense of abuse of a company funds or reputation, especially if he participated in or actually carried out managerial duties within the company. This follows from the general principle set forth in Article 834 of the Commercial Code, which states that the criminal liability of board members applies regardless of whether they are actual board members or individuals exercising management functions, the article provides the provisions of this chapter relating to the chairman of the company, its administrators, and general managers shall apply to any person who directly or through another person exercise the direction of these companies or introduce them under the premises or place of their legal representative. Secondly, the accomplice. Liability may also extend to any member or members who participated in the offense of abuse of company funds or reputation, based on the conditions laid down in general criminal law, if it is proven that the accomplice was aware of the company elements of the act and provided assistance or encouragement to the principal offender, for example, by giving instructions or guidance that strengthened the latter's resolve to commit the crime, he shall be punished with the same penalty established for the principal offender. An accomplice in this crime may be a member of the board of directors, the board of the supervisory board, a shareholder, or an employee of the company. So, for the penalty, according to Article 811, first paragraph of the Commercial Code, the penalty for the crime of abuse of company funds or reputation is imprisonment for a period of not less than 1 year and not more than 5 years. بالنسبة للمصطلحات، القواعد الموضوعية نقصد بها substantive rules، القواعد الشكلية نقصد بها procedural rules، العقوبة الشخصية personal penalty، الفاعل الأصلي principal offender، المسير أو من في حكمه manager or person acting in his place. كذلك مجلس المديرين board of directors، مجلس المراقبة supervisory board، also الشريك أو المشارك accomplice، النية السيئة bad faith أو mens rea، تطبيق واسع للنص broad interpretation of text، رئيس مجلس الإدارة chairman of the board of directors، المدير العام general manager، الشخص المعنوي legal person، الجنحة offense or misdemeanor، المسؤولية الجزائية criminal liability، الحبس imprisonment، المادة 811 من القانون التجاري article 811 of the commercial code. For the abuse of authority or voting rights, the Algerian legislature, influenced by French company law, criminalized the abuse of authority or voting rights by company administrators. Article 811, paragraph 4 of the Commercial Code provides the chairman of a joint stock company, its administrators or general company managers who intentionally use their powers or voting rights in a manner they know to be contrary to the interests of the company for personal gain or to favor another company or institution in which they have direct or indirect interest shall be punished by imprisonment from 1 to 5 years and or a fine or financial fine from 20,000 to 200,000 Algerian dinars. From this provision, it's clear that the legislator addressed two distinct but related offenses. Firstly, abuse of managerial authority. Secondly, abuse of voting rights. These offenses harm the company by placing personal interests above those of the corporation. There has been debate among scholars regarding the scope and application of this article. Two main interpretations exist. First view, some scholars believe the provisions aims to punish the abusive use of blank proxies or similar authorizations granted to administrators to represent shareholders in general meetings. Second view, other scholars argue that the term powers refers to the legal authority granted to administrators by law or the company's bylaws, not merely proxy powers. Under this interpretation, the crime concerns the misuse of official decision-making powers for personal benefits. The courts have not fully adopted the second interpretation, as it could blur the lines between abuse of power and abuse of company funds. Some scholars argue that abuse of power is simply a form of abuse of company funds, as both involve misuse of entrusted authority. However, despite overlapping elements, abuse of voting rights has its own distinct features and legal framework. It does not necessarily require financial damage to the company, distinguishing it from other forms of abuse. So, بالنسبة للمصطلحات في اللغة العربية، التعسف في استعمال السلطة abuse of authority، التعسف في استعمال الحق في التصويت abuse of voting rights. Also مصطلحات مثل القائم بالإدارة، رئيس شركة المساهمة، والمديرون العامون قد كنا اطلعنا عليها administrator, chairman of a joint stock company, general managers of the company, and in the final area نتحدث عن سوء النية bad faith ولا mens rea. For the conditions of managerial liability, the legal text regulating liability clearly indicates that responsibility falls on the member who committed the fault in order for the plaintiff to obtain compensation. It is necessary to prove, firstly, the existence of fault, secondly, the occurrence of damage, and thirdly, the causal link between the two firstly mentioned. The faults. Fault may appear in two forms: proven fault and presumed fault. We will first address proven fault, followed by presumed fault. Proven fault, based on the definition of fault as a violation of a prior obligation, liability can be contractual faults or delictual faults. If the injured party is a shareholder or a third party, the type of fault determines the applicable legal basis. It follows that managers are only liable if the plaintiff proves the existence of fault unless the legislator has established presumed fault, such as in cases of insolvency or failure to pay debts. Accordingly, the civil liability of board members can be divided into contractual liability and intellectual liability. Contractual faults. This form of fault arises from the contractual relationship between the company and its administrator. It gives rise to the company's claim against them. In this context, board members are considered agents of the company and are required to perform their duties with care and diligence. The fault may consist of deviation from the scope of authority granted to them or negligence in fulfilling their duties. The burden of proof lies on the injured party to demonstrate the existence of fault, the resultant damage, and the causal link between them. Importantly, the law does not require the fault to be serious or fraudulent. Example of fault leading to liability: violation of mandatory legislative or regulatory provisions, breach of the company's articles of association or bylaws, failure to prevent the invalidity of company contracts due to the negligence, neglecting the duty of supervision and control by the board of directors, frequent absence from the board meeting, failure to monitor the activity of the chairman or general manager, receiving excessive remuneration beyond what is legally allowed, granting cash loans contrary to legal provisions, failing to record minutes المحاضر of board meeting, not convening the annual general meeting, or failing to call specific categories of shareholders as required by Article 816 of Commercial Code, preventing shareholders from exercising their right to access corporate documents, violating quorum or majority rules, engaging also in acts outside the scope of the company's purpose as defined by law, failing to obtain prior approval from the general meeting for transactions requiring such authorization, poor management of company affairs, such as failing to insure company assets against fire risk, delaying payment of taxes, lending company funds to insolvent individuals without adequate guarantees. We have also the delictual faults or extra contractual faults. These arise from tortious conducts under general civil law principles, particularly Articles 76 and 124 of Algerian Civil Code. We have the concept of breach of the company's bylaws. The legislator has established another ground for civil liability of administrators: breach of the company's bylaws. Shareholders have the freedom to regulate many aspects of the company's operations in accordance with its nature and interests. Any violations of these internal regulations constitutes a fault that can lead to civil liability. إذن المصطلحات باللغة العربية: الخطأ the faults، الخطأ التعاقدي also، contractual faults الخطأ التقصيري delictual faults ولا extra-contractual faults. مسؤولية تعاقدية contractual liability، مسؤولية تقصيرية delictual liability. الذمة المالية financial estate patrimony. also المحضر minutes أو المحاضر. النصاب quorum. الأغلبية majority. الإذن authorization. تصرفات غير مشروعة unlawful acts. الإهمال negligence. الضرر damage or harm. علاقة السببية causal link. For the legal distinction, we have the social action versus the individual action. In this context, it is important to distinguish between two types of actions. Social action brought by the company itself to repair damages suffered by its estates due to the fault of one or more of administrators. Secondly, individual action initiated by a shareholder personally affected by administrative misconduct aiming to compensate individual damages rather than those affecting the company patrimony. For person the corporate bail, addressing the misuse of limited liability. We have the personal liability of managers for financial shortfall. The Article 578, paragraph 2 of the Algerian Commercial Code states, in addition to the above, the court may, in case of company bankruptcy resulting in a financial shortfall, order upon request of the judicial administrator that the debts be borne proportionally either by the directors, whether they are shareholders or not, or by the shareholders or some of them, either jointly or separately, provided that the shareholders involved actually participated in the company's management. It is important to note that while this provision is clear and precise for limited liability companies or SAR in French, the equivalent provision for joint stock company SPA lacks clarity. Article 715 bis 27 states, in the case of judicial liquidation or bankruptcy, those referred to in the provisions related to judicial liquidation or bankruptcy may be held personally liable for company debts under the conditions set forth in those provisions. From these provisions, it appears that the Commercial Code imposes strict civil liability on administrators based on presumed fault. However, this is considered ordinary liability because the presumption is refutable and does not exclude the possibility of proving otherwise. بالنسبة للمصطلحات باللغة العربية، القرينة البسيطة simple presumption، قرينة قاطعة irrefutable presumption، رفع حجاب الشخصية المعنوية person the corporate veil، العجز المالي financial shortfall. We have also another possibility is extending bankruptcy procedures to administrators. The Commercial Code imposes several criminal penalties on persons entrusted with company management if they conceal assets following insolvency or bankruptcy proceeding. Article 318. However, a key question arises: can bankruptcy or judicial liquidation procedures be extended to administrators themselves if they fail to cover debts resulting from financial shortfalls? Such an action would be unusual as it contradicts two fundamental principles of commercial law. Firstly, personal non-involvement in trade. Managers do not conduct independent trade activities under their own name and account. Secondly, lack of trader status. Administrators generally do not operate as traders, which is prerequisite for being subject to bankruptcy procedures. It should be noted that extending bankruptcy to individual administrators contradict Article 215 of Commercial Code, which requires a person to be recognized as a trader to undergo judicial liquidation or bankruptcy proceeding. بالنسبة للمصطلحات: الإفلاس الشخصي للمدير personal bankruptcy of the manager، تسوية قضائية شخصية personal judicial reorganizing، وكيل التفليسة judicial administrator or liquidator، العجز المالي financial shortfall، تسديد الديون repayment debts، الإفلاس bankruptcy or insolvency، التسوية القضائية judicial reorganizing، also الذمة المالية financial estates patrimony. صفة التاجر merchant status، التاجر commerçant or merchant، العمل التجاري commercial activity. For the judicial evaluation of managerial faults, in the document provided to you, you will have access to negligence cases, resolution time, and governance impacts. For the conclusion and key takeaways, you have the legal frameworks. Legal frameworks outline acceptable managerial conduct, the judicial evaluation. Judges assess whether managerial actions were reasonable at the time. Also, preventing abuse. Preventing abuse requires a clear understanding of legal definitions surrounding company interests and corporate governance. Effective corporate governance ensures managers act in the company's best interest. Also, actionable steps. Companies should implement strong internal control to monitor managerial actions.